Oh. I forgot to click the go live button on YouTube. So I've been literally talking to myself for like the last 8 minutes. So I guess I'm starting all over again. All right, I've been reading this by myself for like the last 6 minutes, so we're gonna start this all over again. It's awkward. Okay, hello guys, welcome. Happy Wednesday. Happy Hump Day. Hope you guys have been doing well. We are now doing part 2 of Kim Blandino, and I was going to say we. We are going to go through more antics from Mr. Blandino that ultimately leads up to his current criminal situation, including his appeal from his criminal matter, or the result or his federal appeal of his conviction that he talked about last time we were here, his reckless driving. The opinion which labeled him as a vexatious litigant by the state of Nevada, and then we're going to move on to videos from involving judges who have tried to implement a temporary protective order against Mr. Blandino. So I'm going to start all over again. And we're just going to pretend that I did not like talk to myself for 5 minutes straight. All right, here's the order from that he filed in federal court regarding his reckless driving or traffic violation appeal. Petitioner has filed a motion to file First Amendment petition, which the court grants. The court has reviewed the First Amended petition under Rule 4 of the rules governing Section 2254 cases in the United States District Courts. The court summarily denies the petition because it is without merit on its face. This action arises out of conviction in the Las Vegas Municipal Court. Petitioner appealed the conviction to the 8th Judicial District Court of the state of Nevada, which dismissed the appeal. 4 of the 5 grounds lack merit for the same reason. Ground 1 is a claim that the Las Vegas Municipal Court lacked jurisdiction because petitioner is charged solely with a violation of the Nevada revised statutes, and state law requires that he be charged with a violation of a municipal ordinance. Ground 2 is a claim that the Las Vegas Municipal Court did not issue a written judgment of conviction. Ground 3, if you recall, that was one of his issues that he brought up with Judge Bear on Monday. Ground 3 is a claim that the state district court's dismissal of the appeal because the petitioner did not file a transcript was incorrect. Another thing he brought up, and he brought up with other litigants about this whole thing with a transcript. Ground 5 is a claim that petitioner's appeal needed to be heard by a 3-judge panel and not by 1 judge. All of these claims are violations of state laws. Quote, a federal court may not issue the writ on the basis of a perceived error of state law. Pulley v. Harris, 465 U.S. 37, 1984. Consequently, grounds 1, 2, 3, and 5 are without merit. In ground 4, petitioner alleges that the state district judge dismissed the appeal because the judge's antipathy towards petitioner's religious because of the judge's antipathy towards petitioner's religious beliefs and practices. However, petitioner himself alleged in ground 3 that the state district court dismissed the appeal because he failed to file a transcript with his appeal. That decision is independent of any bias that the judge might have had. Ground 4 is without merit on its face. To appeal the denial of a petition for a writ of habeas corpus, petitioner must obtain a certificate of appealability after making a, quote, substantial showing of a denial of a constitutional right, end quote. 28 USC 2253, Section C. Where a district court has rejected the constitutional claims on the merits, the showing required to satisfy 2253C is straightforward. The petitioner must demonstrate that reasonable jurists would find the district court's assessment of the constitutional claims debatable or wrong. Reasonable jurists would not find the court's determinations on petitioner's claims to be debatable or wrong. The court will not issue a certificate of appealability. It is therefore that the motion to file First Amendment petition is granted. It is further ordered that the First Amendment petition is denied. It is further ordered that a certificate of appealability will not issue. So that's the end of that. Next, I think is the... Oh! I forgot about this one. If you guys recall that he tried to invite himself into a court case on Monday, right? Well, Don Clausen and Kim Blandino, petitioners versus the 8th Judicial District Court of the State of Nevada, and the Honorable Rob Baer, the Judge Baer. And this issued December of that year, December 15th, 16, 2015. Clausen asserts that the district court refused to consider the merits of a motion to dismiss the complaint filed pursuant to NRS 189.070 and erroneously instructed Clausen to file a brief in his misdemeanor appeal. Clausen seeks an order directing the district court to consider the merits of his motion or requests the court to consider the merits in the first instance. Clausen further complains that he was required to pay for transcripts in order to prosecute his misdemeanor appeal, and that the district court has erroneously looked to guidance from the Nevada Rules of Appellate Procedure and determining the procedures for prosecuting a misdemeanor appeal. Finally, Clausen seeks an order referring Judge Baer to the Judicial Discipline Commission. We have reviewed the documents submitted in this matter, and without deciding upon the merits of any claims raised therein, we decline to exercise original jurisdiction. It does not appear from the documents before this court that a written order has been entered regarding the motion to dismiss the complaint, and the basis for the district court's decision is unclear. Thus, we cannot say that the district court erred in denying the motion. Although Clausen is correct that NRS 189.030 requires the lower court to transmit the transcripts, NRS 189.030 does not address the costs of the transcripts. The cost of the transcripts may be assessed to a non-indigent appellant. Remember what we said on Monday? See NRS 4.410, Section 2, providing that the fees for transcripts and copies of the proceedings in the justice courts must be paid by the party ordering them. NRS 5.071, Section 1, providing that the practice and proceedings of the municipal courts conform as nearly as practicable, whatever, to the practice and proceedings in the justice courts. And Braham versus 4th Judicial District, holding that when a justice court decision is appealed, the justice of the peace sends the case to the district court within 10 days, and costs of transmission can properly be assessed to the non-indigent appellant. Nothing precludes the district court from looking to the NRAP for guidance in facilitating the processing of misdemeanor appeals. Finally, Clausen's arguments regarding Judge Baer are inappropriately raised in a petition for extraordinary relief in this court. See NRS 1.4655, Section 1, providing that the commission may begin an inquiry based upon a complaint, and appear to be made with the intent to harass and vex the judge, as there does not appear to be any basis in fact for the challenges to the judge's mental faculties. Clausen is cautioned that he may be sanctioned in the future if he makes accusations of this nature that do not have any supporting facts, or if he raises claims for an improper purpose. Now talking about petitioner Blandino. It is not entirely clear from the pleadings before this court if Blandino is asserting the same claims for relief as Clausen as the petition does not adequately distinguish the arguments applicable to each petitioner. To the extent that Blandino is raising the same claims of relief as Clausen, we decline to exercise original jurisdiction for the same reasons set forth above, with the exception of the claim relating to NRS 189.070 and any claims regarding the transcripts. Regarding NRS 189.070, it does not appear that Blandino's challenge is ripe, as the documents before this court do not indicate that he's filed a motion to dismiss the complaint or has denied consideration of the motion, and his appeal remains pending before Judge Miley. We cannot evaluate any claims relating to transcripts, as Blandino has failed to provide any documents for supporting this claim. Blandino has further cautioned that he may be sanctioned in the future if he makes accusations of the type raised in this petition that do not have any supporting facts, or if he raises claims for an improper purpose. Accordingly, we order the petition denied. So that's what happened with one of his cases. Now we get to the juicy bits, and that is the order which labeled Mr. Blandino a vexatious litigant in November 16th, 2018. And from there on out, we can go to some of the videos. Before the court, our petitioners amended emergency petition for a writ of habeas corpus pursuant to 28... Oh, wait. No. Oh, I almost spoiled it. Crap. I almost spoiled it. Ah, there we go. This is it. My bad. That's what I thought. This is July 2018. Blandino versus Herndon. This having come on for hearing on June 28th, 2018. Kim Blandino, having notice of said hearing, having filed a document entitled... Oh my god. Okay, one thing that Kim Blandino really loves to do, is title his motions and petitions in paragraphs. Like, we're talking... I mean, if you're a fellow weeb like me, we're talking light novel status here. Having filed the document entitled Emergency Motion to Quash Order to Show Cause, or in the alternative, if the Chief Judge Gonzalez will comply with the mandatory language of NRS 3.02 and sets up procedures that do not require the filing of a civil action complaint, Kim will voluntarily dismiss this suit, or in the alternative, if Chief Judge Gonzalez will not comply with NRS 3.026, Kim requests that Judge Gonzalez resign as Chief Judge. End quote. That is the title of his motion. On June 7, 2018, in response, Kim Blandino appearing in proper person in the court, having read and considered the papers filed by Kim Blandino, and having heard and carefully considered the demeanor and presentation of Kim Blandino, the oral statements made by Kim Blandino, and the written materials submitted by Kim Blandino, and with the intent of deciding the issue identified in this court's order to show cause filed on June 5th, 2018, and to, I am not going to repeat the title of that. Yeah, I'm just going to call it the motion to quash. The court makes the findings of fact and conclusions of law related to whether Kim Blandino is a vexatious litigant. 1. Kim Blandino repeatedly files unmeritorious motions, pleadings, and other papers in this and other cases. 2. Kim Blandino's filings are repetitive and appear to be filed merely for the purpose of harassment. 3. After evaluation of numerous submissions in this case and in cases, various criminal cases and appellate cases, filed by Kim Blandino, which were separately evaluated, the court has determined that the submissions, whether a motion, petition, or other type of submission, are harassing, frivolous, and extremely burdensome to the court. Kim's Blandino's continued attempts to act as counsel for other litigants and as an interloper in cases he is not a party is frivolous, disruptive to the rights of litigants, and extremely burdensome on the court. In case number A547536, in denying the second motion to disqualify, the court found that Kim Blandino filed the second motion to disqualify, quote, solely for the purpose of disrupting and delaying the adjudication of the instant case. Patterns. In case number C302515, Kim Blandino had limited access to certain portions of the Regional Justice Center due to inappropriate conduct on multiple occasions in Department 32. This conduct including, quote, sitting at counsel table with multiple propria persona appellants during their court appearances, end quote, where he was not a party, and attempting to represent the interests of appellants with ongoing cases, although not licensed as an attorney. The Nevada Supreme Court denied the petition for extraordinary relief related to that order by written order filed 6/16/2016 in case number 68761. In case number A764148, the co-plaintiff has alleged that Kim Blandino's conduct in that case, as well as another criminal case, is for improper purpose. Plaintiff Blandino was attempting to collateral attack on the return of these financial documents through Judge Herndon by attempting to threaten him into enforcing the order previously made by another sitting judge, and has taken off on a tangent and or personal vendetta against Judge Herndon. He has begun. This is the other co-plaintiff in this case. This is the other co-plaintiff writing this. He has begun threatening Judge Herndon with similar threats that he has made to this court. As such, plaintiff, which is the author, Gary Walters, has determined that Mr. Blandino's has completely lost his focus and is now pursuing his own interests instead of the interests of his co-plaintiff, which is to pursue the return of over $100 million and later even more. Mr. Blandino's pursuit of the tangential issues has taken on a surreal manifestation in this case, and now the plaintiff can no longer be associated with this type of egomania or cockmanship, which on its face appears to be the manifestation of some kind of maniacal or mental defect. Whew. Oh my God. The part 8. The quote, emergency complaint / grievance pursuant to NRS 3.026 and EDCR 1.30 and 7.10 against Judge Douglas Herndon and other collateral matters directed to Chief Judge Gonzalez, including demand that Chief Judge Gonzalez issue an administrative order that sets procedures pursuant to NRS 3.026, or in the alternative, in a writing accessible to the public, set forth such procedures so that the public and the parties can know how to file grievances or complaints as contemplated by NRS 3.026, or in the alternative, any legal action that brings this filing before Chief Judge Gonzalez in her capacity of Chief Judge, end quote. That was another title of one of his fucking motions. All of that. In case number A77547-J, appears to be filed as a result of this court's written order filed on March 27th, 2018, denying the emergency ex parte notice, quote, the emergency ex parte notice of demand by amicus curiae Kim Blandino, quote, Kim, for Judge Herndon pursuant to ground NRS 1.302C, so that Kim and Judge Herndon are free to settle the matter of Judge Herndon's multiple violations on January 18, 2018 of the revised Nevada Code or Judicial Conduct Code and of Kim's civil rights, and to avoid having to file a complaint with a Commission on Judicial Discipline and or file a civil rights complaint, end quote. All of this, all of what I'm highlighting is the title of one of his motions. filed in case number C-05-217-569-1 and the related filings as part of Judge Herndon's affidavit. In response to that motion, it was reported that Kim Blandino attempted to approach counsel table, although neither a party nor licensed attorney, and attempted to appear in a criminal case, although neither a party nor a licensed attorney. We'll get to see the we'll get to see the video that highlights this. I promise. Well, Mall Cop, most of the time, motions are very simple. It'd be like motion for a temporary protective order. Motion to enforce litigants' rights. Motion for a writ of mandamus. Okay. 9. The court finds, after evaluation of numerous filings made in this and other matters, the materials presented for consideration and argument made during the hearing on the order to show cause, and after considering the demeanor and presentation of Kim Blandino in open court, that Kim Blandino is a vexatious litigant. The guide to determining whether to declare a litigant vexatious in Nevada Supreme Court in Jordan versus State Department of Motor Vehicles 121 Nevada 44 2005 adopted a 4-factor analysis as originally set forth by the Ninth Circuit. 1. The litigant must be provided to reasonable notice and an opportunity to respond, the show cause hearing. 2. An adequate record illustrating the specific cases, documents, and reasons in support of a vexatious litigant classification must be created. 3. Substantive findings as to the frivolous and harassing nature of the litigant's actions must be made. 4. The restrictive order must be narrowly drawn so as to protect the litigant's constitutional rights. In detailing this 4-step process, the Nevada Supreme Court carefully noted the purpose of this approach was to curb flagrant abuse of the judicial process while ensuring litigants' right of access to the courts. Because, as you guys know, you have a constitutional right to access to the courts. Because vexatious litigant orders restrict this right, they must be based on adequate justification supported in the record and narrowly tailored to address the specific abuse. The court further noted that the appropriate standard of review for restrictive orders is the abuse of discretion standard. 11. Kim Blandino has provided a reasonable notice and opportunity to respond. He has. 12. Kim Blandino's request that this court voluntarily recuse itself is denied as no basis for recusal exists. Because of course he asked for the judge to recuse. Kim Blandino's request that this court disqualify itself based upon his oral request is denied as there is no pending written motion for disqualification. No basis for disqualification exists. Again, this guy's been doing this for a very long time, apparently. Kim Blandino's request that this court adjourn these proceedings so that he may file a written motion for disqualification is denied as the issues raised by Kim Blandino have been known to him since at least June 7, 2018 when he filed the motion to quash. 15. Kim Blandino's request that this court stay the proceedings so that he may seek extraordinary relief is denied as the issues raised by Kim Blandino have been known to him since June 7, 2018. Kim Blandino's request that this court may adjourn these proceedings so that he may file a written motion for... We already said... Oh, God, these things are running over into each other. 17. The motion to quash is denied as there is no good faith basis raised by Kim Blandino to quash the order to show cause. Kim Blandino's submissions are made for an improper purpose. The materials submitted by Kim Blandino in this matter are designed to harass. It is hereby ordered that in the 8th Judicial District, Kim Blandino may not stand in front of the bar in any hearing in which he is not a party, nor may he sit at counsel table in any hearing in which he is not a party. It is hereby ordered that in the 8th Judicial District, Kim Blandino may not file any new materials in this case as a proper person without first obtaining leave from the Chief Judge. It is hereby ordered that in the 8th Judicial District, Kim Blandino may not file any new litigation as a proper person without first obtaining leave of the chief judge. It is further ordered that if Kim Blandino feels he has a meritorious claim or action that he wishes to file in the 8th Judicial District, Kim Blandino may obtain permission from the chief judge pursuant to the following procedure. All communications between Kim Blandino and the 8th District must be made in writing and contain appropriate content. Kim Blandino may submit in writing, by hand delivery or mail, the petition, motion, claim, or complaint which he seeks to file to the clerk's office. The chief judge or the chief judge's designee will review the submission. If the chief judge or the designee determines that the submission is non-frivolous and made in good faith, the submission may be provided to the 8th Judicial District Court's clerk's office for filing upon presentation of any applicable filing fee. If the submission is rejected, or if Kim Blandino does not follow the submittal procedure, Kim Blandino may be sanctioned by this 8th Judicial District Court in the amount of $100 per violation, payable to the Legal Aid Center of Southern Nevada. The 8th Judicial District Court determines that this is the amount which is the minimum to ensure that future frivolous filings are not made. If the court determines that in the future that this amount does not deter Kim Blandino, the court may make a determination that the sanction amount is insufficient to deter his conduct. They may sanction Kim Blandino further in accordance with the provisions of NRCP 11, and or that Kim Blandino may be held in contempt pursuant to NRS Chapter 22. So, that is the order that he's been labeled a vexatious litigant. Now, we're going to go with the final. This is the final one before we're going to the videos, I promise. But of course, in pure Kim Blandino fashion, he filed an appeal of this vexatious litigant order to the federal courts. And this is what they said. I promise, it's very short. Very short and sweet. Before the order, our petitioners amended emergency petition for a writ of habeas corpus pursuant to 28 U.S.C. 2254. This court has reviewed the petition under Rule 4 of the rules governing Section 2254 cases. Petitioner is not in custody, and the court lacks jurisdiction. The court dismisses the action. Remember, Blandino filed a habeas corpus petition on an order labeling him a vexatious litigant. A habeas corpus petition is reserved for when you're in custody, when you're in jail or prison. Petitioner alleges that Judge Gonzalez has sentenced petitioner to life without any possibility of parole. This is hyperbole. Judge Gonzalez of the 8th Judicial District Court of the state of Nevada has entered a vexatious litigant order against petitioner. No judgment of conviction exists, and petitioner is not in, quote, custody, end quote, within the meaning of that term in the habeas corpus statutes. This court lacks jurisdiction under either 28 U.S.C. 2241 or 28 U.S.C. 2254 to consider petitioner's petition. The court cannot also construe the petition to be something else because the court still will lack jurisdiction. The state courts have their own procedures for managing vexatious litigants, and petitioner needs to follow those procedures. No provision of federal constitutional or statutory law exists that would give this court jurisdiction to issue orders to a state court about how to manage their vexatious litigants. For the same reasons, the court also denies petitioner's emergency motion to stay the state court proceedings. So yeah, the court just smacked him down like, what the fuck are you doing? Submitting a habeas corpus petition on a vexatious litigant order. Go away. So, now we'll get to the fun stuff. I imagine a lot. Well, yeah. Okay, I'll go with the super chats, and then we'll start off. Colony, L3 199 for the post-it note. Hit the go live button. Love you. Thank you, Colony. Dr. Joker, someone get Radical to fire his facepalm cannon at Artie. Thank you, Doctor, for the $5. Cameo Stark, $5. Can't say because I have another essay to write. We'll rewatch the stream. Loki says hello. Aw. Okay, cute. Joshua Lee, member for 3 months. Thank you very much. Hit the button, Frank. Yeah, I know. Akira 808 State, $4.99. Everybody makes mistakes. Don't sweat it, Artie. Thank you. Colony L3 199. Is this the guy who writes anime titles? I know. He sounds like it. Joshua Lee $5. If those are titles, how long are the filings? Exactly. $2. How hard is it to be unvexatious litigant? I mean, honestly, I couldn't tell you, Kit. I really couldn't tell you. Tones overthinks it. $2. Wow, are we absolutely, I guess, absolutely certain he's not a soft? He doesn't fit the ideology, honestly. He says a couple of things that sound like it, but based on his filings, no. He is simply one of those guys who will not take no for an answer. So I imagine most of you guys have seen this video before, because I think this was one of the videos I was displayed in court camp, and this is the one with Judge Herndon, and it involves that one other plaintiff who was in what we just read, where he's like, Blandino has completely lost it. I don't know what he's doing, and I don't want anything to do with him anymore as co-plaintiff. So that's what this is at.
Page what? 10. Page 10, Mr. Walters' matter, 217569. Mr. Walters, how are you?
Hi, Judge Herndon. Pleasure to see you again.
Nice to see you.
We're back again, but I
that's
followed
okay.
your advice, and it didn't really get us anywhere.
Well, yeah, I get it. I mean, there's not a lot I can do about that, though, understand.
But I think this might be of interest. I went back to my parole officer. I've been making my payments. I've been on Social Security. I've been paying what I can in restitution.
Okay.
All of a sudden, he hit me with a stunning thing. He says, "You got to pay $26,000 a month." And I go, "Well, I know all this restitution, but there's never no real figure." He says, "Well, that 10 days a month you're getting is gone."
Okay.
And it's going to push my liberty interest way out.
Okay.
So here's Weatherford.
Meaning your parole officer saying you're not going to get your good time
Yeah.
monthly if you're not paying restitution.
He says you're going to have to go back. I can't do anything about it. You're going to have to go back to the original court.
Okay.
You got to let them know about the liberty interest and that, and then possibly.
Hey, hold on a second. Who's this guy staring at me over here?
This is Kim Blandino.
I'm trying to appear amicus curiae. I'm a co-plaintiff
Amicus Curie.
in the civil case. Trying
Okay,
to
are you an attorney?
No, not
Then
at all.
then you need to sit down and quit staring at me like somehow you need to talk to me or whatever.
I
'cause
do
you're
need
not-
to.
Pardon?
Can I make a record?
No.
Okay.
I'm going to make a record about you in a minute, but you need to sit down and be quiet because you're not a plaintiff or a defendant in my criminal case. You're not an attorney. You can't appear in my criminal case and act like an attorney, so sit down and be quiet.
Thank
Mr.
you,
Walters,
Judge.
go ahead.
Apologize. But anyway, so
Okay, so just to give a brief background of what's going on, this guy who's the plaintiff who's talking, he was convicted of some sort of a financial white-collar crime, and he's being required to pay restitution. Apparently, what's happened is his lawyer, his attorney in his case, is withholding apparently a COD from him that's supposedly worth $100 million, and he's trying to get it back. He's trying to petition the Judge Jordan, who's the judge is in his criminal matter, to get it back. What the judge is going to tell him is that he can't do anything for him because that your remedy is a civil remedy. You need to file suit against the attorney to get your stuff back. $100 million. $100 million. So, the judge is trying to tell him, like, I understand where you're coming from, but you have to file this in civil. You have to file a civil case. I can't do that as part of the criminal matter. That's the background. Well, the problem is that Blandino introduced himself to this plaintiff, and apparently there's some sort of agreement. Allegedly there was an agreement made between him and the defendant talking that if Blandino's able to get that COD back, he would get like 20%, 20 or 25% of the COD. That's an alleged agreement between the two of them. I think that's what Blandino claims was the arrangement.
Well, I told my parole officer I would try and see if I can go back in front of Judge Herndon and explain the liberty interest part, since that has an effect on that and the restitution. Here's Weatherford. He went in and got the Supreme Court to list him as disabled, right? Okay. Still practicing law and all that. He's now demanding $250,000 in extortion fees. He says he'll give me the CD back.
Okay.
And I asked him, I said, well, let's do this. Let me see if I can talk to the court and maybe work with the DA's office and see if the DA can help get involved and deliver the CDs and the files to the DA so we can pay this restitution, because them folks are old.
Okay.
They're not going to be here long. I'd like to get this matter paid.
I know, but
We have the ability to do it, and then help me with my liberty interest.
what I explained before, though, is what you're seeking is to force some individual to turn over some property to you. That is not anything that's involved in my criminal case. That's why I said you got to file the civil case.
We did.
You know what? Let me tell you something.
Oh boy, all right, here we go.
Did you file the write the motions in Judge Escobar's civil case?
Yes, we did.
Yeah, you did? Okay, so let me tell you something. When you want to file motions in court and act like an attorney when you're not really an attorney, saying things like threatening the judge about how judges get kicked out of office for misconduct and all your egregious stuff where you don't follow things, you want to act like an asshole, act like an asshole. But I'm telling you, that gets you nowhere in court. And you know what else gets you nowhere in court? Sitting in the audience of a court while a judge is engaging with some...
No, the judge is trying to tell him that he needs to file a civil case. The judge is trying to tell him here and now that he can't do anything for him as part of his criminal case, as part of his criminal matter. He's trying to inform the defendant to file the civil case.
Somebody and shaking your head and being all demonstrative. So get out.
I'm sorry, it was inadvertent.
No, it wasn't inadvertent. Don't give me that. It's not inadvertent. It's never... Get out. It's never inadvertent when you come in and act all disrespectful to people.
Judge Herndon, that is his words, not mine, sir.
I am perfectly aware of what I thought was going on.
He has an interest.
Mr. Walters, I've never had any issue with you being disrespectful at all.
Thank you, sir.
But what I would say is, for whatever reason, that guy's your co-plaintiff. He needs to file his stuff, and you need to file your stuff.
Yeah, I'm going to separate.
You don't want to get a judge all mad at you. But here's the thing. I know you're frustrated with what her order was, but it's a difficult thing to get a judge to the point in a civil case of saying, now I'm going to issue a civil arrest warrant for somebody because they're not complying with certain things.
Right.
There are ways. I mean, you guys could potentially ask her to set up certain type of examinations to occur, and if Mr. Weatherford doesn't comply with that, then maybe you've got a contempt issue to ask for an arrest warrant. But it's not, as much as I would like to help you, it's not within my jurisdiction to order somebody else to comply with something to help you get money so you can pay your restitution.
Is there a way, Your Honor, I could work back maybe through the state and the DA's office and visit with them and have them examine this whole thing and see where we might lie with that?
Not really, because all their real obligation in the criminal case is to make sure you had your discovery in the case, not to make sure your former attorney, who we all agree screwed up a lot of things, provide certain documents and stuff to you that allow you to generate restitution. Their obligation, that would be asking them to basically become your civil attorney to go out and help you pursue something from your former attorney because your former attorney is not being a good guy and complying with what he should comply with. That's why I said the only two options really are go to the bar and see.
Yeah, they denied it.
Yeah,
and only because he said he was disabled and they took him off disabled status, but he's out in Anderson still practicing law.
Yeah, that I don't
And
know.
that's why I was going to talk to the DA's office about it and have him look into that because the Supreme Court gave him a disabled status, but he's still listing on his website and having people come there.
Did you go down to the Civil Law Self-Help Center in the building to try and talk to those people, see if there's any attorney?
I mean, what again, to kind of briefly summarize what's going on, the guy, part of his sentence was to pay restitution, and I guess he doesn't have the money on hand to pay restitution outside of the the certificate of deposit that's being held by his former attorney, and he's claiming that his former attorney is extorting him by saying, "I'm not going to give you back the COD unless you give me 25% of the COD." And he's like, "No, it's mine. What the fuck?" So the defendant unfortunately seems like he's in a real bind. He wants to pay the restitution, but he's afraid he's going to get caught up in a potential further sanction because he's not able to pay restitution on time because the money that he has to pay it is being held by his former attorney.
Attorneys in the pro bono project that would help you out and give you ideas about what it is, because I can't really give you legal advice, but what it is you need to be requesting of Judge Escobar to set up to ultimately get a warrant, meaning you can't just go in right away and say, this guy never returns my calls, I want an arrest warrant. It's to get an arrest warrant in a civil case, you kind of got to be patient and work through a process of showing that somebody is not complying, because it looks like she's issuing orders for things, but
She did great concern.
not the arrest warrant. Yeah, not the arrest warrant that you want.
Yes.
And I know the arrest warrant is what you want because that's probably going to generate the guy coughing up what you need him to cough up. But there's kind of a process that you're going to need to go to get there.
I'll follow that, and I'm trying to separate myself from that. All he has is a little asset, legal complaint, that's it.
Well, and I get why you're co-plaintiffs, but like I said, I mean, it
I'm going to
doesn't.
separate that if I can.
If an attorney wrote that in a pleading in front of me, it'd be
Judge,
bad.
I
It'd be
apologize.
bad,
That's why I
right?
said his words are his words.
I get it. It's all right.
Thank you. God
All
bless
right.
you.
Good luck.
Thank you, Don.
Okay. We'll get back.
Okay, so now we're going to. Okay, so this is a prologue to the next chapter in this story. This judge is a pro tem judge, and he had ruled on Blandino in another separate misdemeanor case. I think it's a traffic violation or something like that. And so now Blandino, being Blandino, is inviting himself to the judge's courtroom. A pro tem means temporary judge. Usually, if the courts are backed up, in some jurisdictions, they can invite private attorneys to have a temporary appointment as a judge to handle simple matters like traffic infractions and whatnot. So now Blandino has been allegedly calling up this judge at both his private practice, at his home, a lot of different things, doing what Blandino does. This is a video of Blandino coming into the judge's courtroom while he's on the bench.
Driving on a $85 warrant. Let me ask you, sir, how much does he owe?
He has to enter play. He hasn't played yet, so he doesn't. At this point, he just owes the warrant.
Mr. Blandino, That's you, right?
Yes, sir, you're addressing me?
I am addressing you. Let me get a picture of you here. Now, you came into my private office about something. Because of that, you can't be in this courtroom right now. So you have to go.
No, I don't think that's true.
All right. Well, I'm ordering you to leave this courtroom right now.
Okay.
And if you don't get out within 10 seconds, okay, 10 seconds, you're going to be held in contempt.
You're out of order.
All right. Have a good morning. Don't stalk people.
Ooh. So now that we got that, we are now going to this judge's petition to issue a TPO, a temporary protective order, against Blandino, and this is that opening hearing.
I believe that's Mr. Dickerson's case. I just sent him a text message. Oh, I apologize.
No, this is the criminal matter.
Oh, okay.
He was here this morning.
Oh, all right.
We handled that.
And I'm gonna get a refill, but I want to say that you guys can correct me if I'm wrong, but I say that this judge sounds like Jimmy Stewart, if Jimmy Stewart was alive and 85 years old. But I'm gonna let you guys be the judge of that while I get something to drink.
Other matter this morning.
Perfect.
Yeah.
I got confused.
Kim Blandino, appearing pro se for Kim Blandino.
Yeah, I know you're present.
Michael Federico.
Okay.
I did see that, philosopher.
Yeah, swear him in. Go ahead.
Your Honor, if I may, don't have my paperwork. Can I have a copy of the complaint and stuff? I asked for.
All right, hold on.
Yeah, swear him in. Go ahead.
Your Honor, if I may, don't have my paperwork. Can I have a copy of the complaint and stuff? I asked for it to be brought up from
You
the jail.
never got one?
No, I haven't, but when I was arrested, I brought it with me. They didn't bring
Okay,
it
hold
down
it,
to
hold
the
it,
jail.
please. Let's be sworn in.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Am I to be sworn in too?
Yeah.
Oh, I state under penalty of perjury before God and man that I will tell the truth. And as far as matters of belief, those matters I believe them to be true.
Okay, I'll accept it. Let's go. All right, what's the problem here? What's the issue?
Excuse me, I
Now,
don't have.
wait a minute. You're the adverse party.
I don't have a.
Why is Blandino talking? He's not the one issuing the petition. The person bringing the petition usually gets to talk first, but of course Blandino wants to go for it.
Copy of the claim. How am I gonna-
You had it. It's in your paperwork, sir.
It's there at the jail. They wouldn't transport me with it.
You had it. You should have read it. What's the problem?
I did read it, but
Please.
Thank you, Your Honor. I've been a pro tem judge in Justice Court since like 2001. Never had any problem with a defendant who appeared in front of me. This individual who apparently is in custody right now, I heard a traffic trial. This is a misdemeanor traffic trial, municipal court, first floor. Maybe 8 or 9 months ago, I don't know, it was sometime in 2018. And then, about 6 weeks ago, he shows up to my private office. And he wants to talk to me, kind of acting erratic, talking to the staff.
Objection,
Staff
Your Honor.
Please.
Objection to erratic. Assumes the facts not in
Oh,
evidence.
Oh my god. Assumes facts not in evidence.
This is a civil hearing. Go ahead.
This is a civil hearing. You son of a bitch.
So anyway, making the staff nervous. I kind of keep an eye on things from up above. I didn't really remember the name, but I remembered the voice as I looked over from the second floor. Kept an eye on things, so I didn't call Metro about him. Looking for Judge Federico. I'm like, this has never happened. It's kind of freaky as a layperson. So ultimately, after about 20 minutes of hanging around in the lobby, not wanting to leave, he writes me a letter. Letter that was pretty much, hey, look, you heard this trial form, you were the judge, and if we don't talk compensation, whatever it says, it's attached to the documents. Compensation, then I'm going to go make a judicial complaint against you. Well, I've never seen something like this before in my life. Kind of panicked, kind of concerned, think I got to look over my back, talk to some people, and then go to Metro. So next morning I walk over to Metro, Northwest Command was right next door to the office. I also call administration because it's talking about me as a judicial, in my judicial capacity as a pro tem. And contact the DA's office, contact GADA's. I'm like, I don't know what's going on here. What's the problem? This is highly unusual in my experiences. Be on the lookout. This person's a problem. And that was it. Then about 3 or 4 weeks later, I'm sitting downstairs in that municipal traffic court, hearing traffic matters. And he strolls in, plops down right in front, kind of with a smirk on his face.
And that he's describing what we just saw. Blandino sitting down while he's on the bench.
Catches me off guard, and I'm like, you gotta go. You can't. You sent me this letter, and you gotta get out of here. Puts up a little bit of argument. It's all videotaped. And then ultimately, after I threaten him with contempt, he leaves the court. That afternoon, guess what? He drives back to my private office again. This time with some kind of typed up letter. Similar. I didn't really read it. I kind of skimmed it. It was the same kind of threats going to the judicial panel. The fact that he lives downtown on like 16th Street, and he's driving some 30-year-old pickup truck all the way up to Cheyenne and 215 to do this.
Well, let's just get to the bottom line, what it is. I mean, I know it's all this,
Sure.
what is the issue?
Harassed me at my office, emails, telephone calls. He sent an email to a bunch of my colleagues about my something about misconduct. He's harassing me. I look over my back. I have a concealed weapon permit, but I haven't packed in years. It's made me think about it. I'm concerned about showing my house. He goes in my office. He tries to get me fired from my job, from some kind of baseless claims because he's not happy with a traffic matter. It was a traffic trial that kind of went the way you just experienced.
Imagine getting to Blandino's place. You're doing all of this. You're going to the judge's private practice. You're going to his court when he's not around, filing all these sending all these letters, these motions for a simple traffic case.
So I'm looking for an order of protection for this harassment. Trying to get me fired from my job. Threatens me, harasses me, concerned for my safety. Like I said, I have weapons. I don't like carrying them, but it's a concern. And obviously, I just heard that he had some problems with even being on house arrest for the felony charges currently, I think, in this department regarding the extortion plot against me that was baseless anyway. So I think you probably get a little bit of the gist of it from experiencing him just now, what I dealt with for probably a couple hours over traffic. But I don't want him bothering me, and I know, I've heard anyway, that in his felony case that's in front of this court, that there is a stay-away order from me. But, I mean, I did all I could to wait, because I never did this before. I've heard these before, but I've never did this before as a litigant.
Yeah. Imagine being an attorney for like 20 years. Imagine being an attorney for like 20 years and like, this is the first time I've actually had to do this for myself, Your Honor. This is kind of new for me.
I did everything just to wait to see what happens with the criminal matter, because I really didn't want to do this. But because of the chance that there was no stay-away order, because of, obviously, he has some kind of problem with authority, unfortunately, here I am today after making a court appearance for a client, hearing for myself, and saying, hey, we need some orders in effect with some teeth.
All right.
That's all.
All right, Mr. Blandino, what's your story?
Don't I get to cross-examine the witness? If this is a prosecution.
Well, ask him a question. Go ahead.
Oh, yeah, I'll ask several questions.
Yeah, it's going to be limited to a few of them.
Isn't it true that
There's got to be limited to a few of them. We don't got all day.
Mr. Federico, that I made a complaint with the customer feedback form, then typed up a thing, and then went over to your office on that same April 2015?
I have no doubt. I don't know anything about that.
You attached them as exhibits.
I didn't even look at them. I mean, they weren't that important.
You attached the exhibits to this
Important
very...
thing
Hold
shows
it.
my private office threatening me. That's all that's
Hold
important.
it, hold
Not any kind of
it.
mumbo
One
jumbo.
at a time. One at a time. You got a couple more questions?
Yeah, am I only going to get a couple more questions?
Well, we got a long morning.
We're not gonna be here all
I
day.
can cross-examine this guy for hours.
Yeah.
Excuse me, isn't it true on the complaint that you attached as exhibit the very letter that was dropped off to you on April 25th, 2019?
Whatever you dropped, whatever you wrote, and then I think just whatever you wrote was attached, of course. I'm going to cooperate with the police in any way possible against a convicted felon like you, sir.
But you just seemed to be
correct.
evasive just a minute ago. This
I'm
is
not the
inconsistent.
kidnapper here, sir.
All right, hold it. Listen. You listen to me, Mr. Blandino.
Blandino.
Excuse me. Are you
Blandino.
going to stop your actions against him?
Your Honor, I need to evidence that this is abusive process, what this man is doing here. There's an ulterior purpose to him doing this. He made a speaker phone call. I've got a witness to that speaker phone call right there. He did it in conjunction with the police. He's trying to make it sound like he never said, Mr. Blandino, I don't want you to show up at my office. I don't want you to contact me in email. That was never said.
Why do you want to contact them at his office? Their case is done. If this is a case that was back in the municipal court, the traffic matter, that case is
I got the
history.
perfect answer for that.
If you weren't satisfied, you could have appealed.
I have appealed it, and I will take it on mandamus to the Supreme Court if
Well,
necessary.
do what
Of course you will.
you have to.
But there's
that's your-
another collateral issue.
Hold it. That is your process. That is the way you should do it. Go the legal route.
I have.
File an appeal. File a writ of mandamus.
I have.
File a writ of certiorari. Whatever it is to get it heard. But stay away from him.
He never told me once throughout this process to stay away. Not once.
Well,
Oh my God.
I'm telling you.
Well, I'm telling you.
That's why this is disingenuous.
Hold it. I'm telling you to stay away.
But
Until this matter is fully resolved.
if you will retract your order, I will guarantee on my own oath that I will stay away from him. I do not want the court imposing something on me that by my own volition I will say under my own word of honor, which I have witnesses to testify,
All right,
I will stay away from him.
Okay, here's what I'm going to do. You said you'll stay away from him.
Yes.
I'm going to continue this for 30 days. Granted, 30 days. You promise me that you stay away from him, then the order will be dissolved.
No, I'm sorry, Your Honor. This is abusive process, and I have a right as an adverse party to make a record because this is a tarnish on my name. I've already been wrongly declared a vexatious litigant by the district court.
Yeah. Oh, by the way, this is 2019, so we're 6 months into his vexatious litigant, or almost a year since his vexatious litigant order.
That is on appeal. I have a Ninth Circuit case regarding another judge's misconduct. I have taken it upon myself to be voluntarily investigate on an unpaid basis judicial misconduct and corruption. Already this year, I've gotten 2 letters of caution issued to Judge Douglas Herndon and Judge Robert Baer.
All right.
I have active 2 complaints now, and I have 3 yet to file.
All right, hold it.
I have a right to
Listen to
investigate
me.
judicial misconduct.
You said you promised that you will stay away from him. If I don't order, you promise to stay away from him.
Now,
Listen to me.
I'm sorry.
Isn't that what you said?
But I would like to make a
Shut the fuck up!
a codicil to that. I should be allowed, as a member of the public, to still come in, as soon as I'm cleared to come into the RJC again, to still come into that courtroom where he's attending and do my
I
investigative
cannot keep you from
capacities.
coming in the RJC. I cannot keep you from not coming in.
Can I come into an open courtroom as long as I'm not disruptive and take notes? I'm also an
I don't know,
investigative
whatever
reporter.
the rules in the RJC, but I cannot keep you from going.
Yeah. See, Blandino was about to ask the judge to circumvent this vexatious litigant order. He tried to pull a fast one on the judge.
Part of Toledo.
That's what I tried to explain earlier this morning.
Part of the judge's order, Judge Cellini's order, said you can't come in.
Exactly, but we need that
that
modified.
was her order.
I am going to ask to modify that order and to...
Now, I'm not going to modify her order.
I know, I understand that, and you're in a tricky position here because you can't go against what another judge. But I'm going to ask for a modification of bail and the modification of the bail conditions.
Now, wait a minute. You already been released this morning back on house arrest. The DA agreed to that.
Oh yeah, we're also. This is also after he's been charged. He's been charged with extortion and impersonating a public officer. Which this guy is actually the complaining witness in those criminal charges.
You got some city manners. I talked to you this morning that you go to the city, you transfer it, get those taken care of. Now, you promised me you stay away from him, and I'm going to set it for 30 days for a status check. Now listen to me. Listen. If it's brought and proven that you had contacted this person in any way within the 30 days, then a TPO will be issued against you for 1 year. You understand that? You promised me that if I didn't order it, you'll stay away.
Except that I can come into an open court? Is that
I
still
don't
an open
know.
question
That's
with you?
not. Hold it. That I did not issue. That's Judge Cellini. Whatever she said, that's in the other case. That she ordered that.
So what I'm asking though, is the stay away order is restricted to his activities outside this, where he's not in the, sitting on the bench where I can take notes and investigate misconduct, further misconduct on this pro tem judge's part.
I cannot. You already got an order staying away from the
But if I get that modified, I want to make clear that if I'm clear to that order on a motion to modify bail or to reduce the restrictions upon me, that I can come into an open courtroom. He's got a marshal. I have a constant marshal.
Okay. Okay, I guess you're allowed in, but you have to stay 100 feet away. I don't.
Yeah, see, I never got a written and signed copy of the order. All I saw was a minute order.
All right, the TPO said that you're allowed in, but you have to stay 100 feet away from him.
So that would be when I'm on the bench, I'm going to be in my courtroom.
Yeah.
Right.
That's 100 feet.
I would respectfully request that a condition of anything that goes on here today is he should be able to prove that he sought gainful employment. That's what I would like to see.
To do what?
Have gainful employment. In other words, have something else to
Objection, Your Honor. This is
No, hold it. Here's 30 days. You promise you stay away.
The petitioner's asking, can we also have proof that this guy's got a fucking job? That he can get a job also, which the judge isn't going to do. That's you can't do that.
I'm going to have a 30-day status check.
all right.
If it is brought the attention that you had contacted him and violated within the 100 feet to stay away, then a TPO will be issued for 1 year.
Now, Your Honor, in fairness, he has to keep 100 feet away from me as well. Is that true?
No.
You 100 feet from him.
No, exactly. Exactly. It's not mutual. The petitioner overcomes you. If the petitioner goes into a grocery store, you need to get the fuck out. Doesn't matter that you were there first. You gotta get out.
What if we go into a Walmart? This happened. Went to Walmart and he comes up.
Will you
he
see
could
him?
say I violated.
When you
I'll stay out of Walmart.
yeah, stay out of Walmart. Okay, all right.
Target, Your Honor.
This isn't funny. I don't know if that's
I'm going to
appropriate.
Target. You go to Walmart.
No, hey, now wait a minute. Now wait a minute. You understand now? You understand? I'm not going to issue any today. You promised me that you stay away from him within 100 feet, wherever it is, here in the courthouse, wherever it is. Stay away from his office. Listen to me. If you do that, we'll to have a status check in 30 days. If you violate that and you do contact them, then a temporary protective order will be issued for 1 year.
Now, if I do run into him in a public setting where surprise, is there a number I can call to be saying, I ran into him, I'm trying to cover my bases, Is there a number I can call? Can I call the judicial assistant to the judge or the law clerk?
We can call the police,
Not gonna do any good.
but that won't do any good.
No, but I'll just say, hey, I ran into him at this gas station or whatever. I don't want him to make a false charge or a false claim because this man is not a truth teller.
All right, you know the consequences. You understand that?
I do understand.
Okay.
So you're gonna issue the temporary for
Yeah.
30 days?
No, I'm going to take on his promise, and I'm going to have a 30-day status check
Okay,
to see if he violates, and then a TPO will be issued.
okay.
Now, if I have court appearances, I will be walking through the courthouse, and he could be there too. So I have a
Well,
marshal
whatever the order at the courthouse,
I have a marshal escort at all times through the RJC. That's been in existence since June of last
well,
year.
then that will continue.
And so they will be my witness. I would like to advise this judge that they will witness, and these are good, honorable men in the marshal service, and that if there is any hanky-panky done where you try to initiate contact,
I'm not the convicted liar you are,
Yeah.
so just stop.
Oh! I'm not the convicted liar, man. You are. Woo! Let's hear that again.
honorable men in the marshal service, and that if there is any hanky-panky done where you try to initiate contact,
I'm not the convicted liar you are,
Yeah.
so just stop addressing me now, please.
Yeah, listen.
No,
I agree. That's enough. Just stay away from him.
I will do everything I can to.
Oh, you're going to.
Yeah.
And we'll have a hearing, we'll have it back in 30 days.
Before you or Judge Cellini?
I'll probably be before me.
Your Honor, we'll need a date and time.
Yeah.
I can just double check my calendar, then I
It'll be
appreciate
July
it.
9th. You said it was granted for 30 days, so it's not granted?
No,
It's gonna go like a cool.
he promised. He told me if I don't grant it, he'll promise to stay away. So let's do it. If he doesn't, then it will be granted for 1 year.
Is this July 19th the date?
July 9th.
July
We
9th.
need a couple days before, well, I'm gonna be out of the jurisdiction, I
Are you-
think, from the 9th to like the 14th.
Oh, hold on.
Make it the 8th.
Yeah, earlier is better for me too.
Okay.
The 16th?
Oh, later?
July.
That
Make
makes
it
it more
earlier,
than
make it
30
earlier.
days.
That's gonna make it more difficult for him to stay away, apparently, Your Honor.
No, if we could just make it earlier.
Um,
30
anyway.
days.
Okay, July 2nd?
July 2nd is
Makes him
good.
feel a little better. What time,
At 9:45.
alright.
And Your Honor, I don't know if I could get an abusive process started that soon, but if I'm doing
That has nothing to
If I'm
do,
doing a suit against this man, then that does not count as contact, correct?
if you do it through the judicial means.
Right.
In other words,
I'll
if
have
you got
professional
papers,
service done if I can get that
listen to
suit
me.
done.
If you got papers, have a server do it.
We'll
Don't
do
do
that.
it yourself.
Thank you.
Don't contact them, whatever it is. I cannot prevent you from filing
Well, you said no
anything.
phone calls, no mails, but, and I just want to
No
make sure.
contact, period.
Right. But
You don't
service
need
of
to.
process is a different
Have,
thing.
have your attorney do it, if you're going to do
I'm
it.
representing myself.
Okay, well, no contact,
Yeah,
period.
he can't serve me and come anywhere where I am, right? I mean,
No,
obviously you can see
I
this-
said he's gotta
you can see
have
the
a
So I'll get a
process, sir.
professional service, legal wings or one of the other
Yeah,
services.
right,
Yeah.
that's
This
what I'm
guy,
saying.
I mean, he's obviously obsessed, as you can see. I mean, it's shocking. I've never had this happen, but, you know.
He's obviously paranoid and he countered.
Hold it, hold
I
it,
think everybody in this courtroom.
hold it, hold it, hold it, hold it, hold it. If you're going to serve, you get wings. I
Right.
haven't served.
Will do, Judge.
You promised me,
Right.
and I'm going to hear it. And I'll be here July 2nd to hear it.
All right. Thank
You
you very
understand
much.
that?
Thank you.
All right. Okay,
All right. And now we are a month later. And we are back. And we're going to see what happens. Let's listen in.
Michael Federico versus Kim Dennis Blandino.
Morning, Your Honor, Michael Federico, petitioner.
Judge, I'm gonna need a second to clear off my desk.
That's all right.
Gentleman has a ton of stuff he wants to bring up.
Okay.
Of course he does. It's Blandino. The man has like 5 banker's boxes that he carries with him at all fucking times. Look at that shit. What the fuck? 1, 2, 3, 4. 4 bankers boxes full of shit.
I'm sorry, I didn't realize. We're gonna be okay.
Thank you.
All right, Mr. Federico, I'm going to ask you one question. You were here 30 days ago. Has there been any contact by the Mr. Blandino to you within the 30 days?
There's been several things that have been brought to my attention. The only direct contact.
Objection, Your Honor.
Oh, just keep
Shut the fuck up.
still.
Oh no.
Okay, Michael Federico, I'm going to ask you one question. You were here 30 days ago. Has there been any contact by the Mr. Blandino to you within the 30 days?
There's been several things that have been brought to my attention. The only direct contact.
Objection, Your Honor.
Oh, just
Seriously.
keep still a minute.
Why is he saying objection non-responsive? He's not. This is a fucking civil case. Blandino, shut the fuck up. You'll get your chance to respond.
And I would like to enter my appearance. I think I have a right to make a record.
All right, just a minute. Okay, I'm asking if there's been any contact.
Since the last hearing, which was about 28 days ago, apparently it's been brought to my attention that he violated his house arrest terms. He was also in
Objection.
court.
No, wait a minute.
That's
Has
not before the court.
Now, in fairness, the petitioner, he's not answering the judge's question, and so the judge is getting rightfully pissed off. Has Mr. Blandino directly contacted you, and he's not answering the question?
Also,
Sir, you're not going to bear it out. You're
But
going to be there,
But also, he's getting pissed off at Blandino for constantly interrupting.
the gentleman. Now, I'm asking again, has there been any contact, direct contact with
direct
you?
contact, no. Except for
There
this
you
morning,
go.
He tried to intimidate me walking in the court.
Okay.
That is a lie, and I will.
Court marshal's right there. He started talking. There he is. There he is.
I was
I'm going
talking
to warn
the
you
marshal,
too.
not you.
I'm going to warn you. All right. What kind of contact was it this morning?
This morning, he started saying, "There he is. There he is," trying to
I didn't
intimidate
call
me
the
as I was
marshal.
walking
If I
into
court's
the
indulgence.
courtroom.
Go with the marshal, please, David.
Why?
Could I enter my appearance, Your Honor? I have a right to make a record here. I'm Kim Blandino, appearing pro se for King.
I know you are.
And this is Michael Federico, a temporary judge. If he would be pleased, if he could announce his bar number for the court and for the record. I
He
think I
already
have a
did
right.
before. It's already been done before the record.
He did not announce his bar number.
All right, what's the problem?
This is the marshal here. He's my escort. I've had a marshal's escort for
All
over
right,
a year
there was,
now.
all right.
And I had told Marshal Gurka here previously.
Was there any, have you observed any contact with Mr. Baldino with Mr.
Excuse me,
Federico?
Blandino for the record.
Baldino.
When I was walking in, he started talking to me and saying things.
He said, it's the gentleman I'm here for court.
I wanted to make sure that he identified the gentleman that we have a stay.
Okay, so that was all that was said?
Yes, sir. That's
Then I don't see there was any contact. So therefore, since there was no contact, then no,
We had a 30-day stipulation, but that was it then.
okay.
And then I just.
Well, if there's any more, if it does come up, because you promised me you wouldn't, and you apparently did, so therefore I am denying your order of protection with him. I know there's one already outstanding in the criminal matter. That has nothing to do with me.
Yeah,
Okay?
there's a geofence around my property and around my.
Well, that's
That's not
office
true.
now.
Hold
That
it.
is false.
Hold it. Since 30 days, there's been no contact, direct contact.
The marshal escort is because right now Blandino has a standing vexatious litigant order in place, meaning that he is forbidden from going to the RJC unless he's there for court business. And so he's only allowed to go to the building if he has court business, and therefore he has an escort while he's there. Because once he's done with his court business, he has to get the fuck out. That's why he has an escort.
You got an order in the criminal.
So right now, the judge is denying Federico's TPO because apparently Kim kept his word for the last 30 days.
Okay, that's not here before me.
I understand
That's
that.
not here before me. So
kick
since there was no
Telemai.
contact, then there's no protective order going to be issued.
Thank you, Judge.
No, excuse me, Judge, I have a right to make a record. There's some administrative and procedural matters.
Of course, I'm honest. I could make a bingo game. Make a record. Administrative procedural matters. I have a standing objection. Motion to disqualify.
The procedural matters are over with.
No, they are not, sir. I object.
You bear in mind the judge just ruled in his favor. The judge just ruled in his favor, and he's being combative with the judge right now.
I object. I have a right to make a record. Give me 2 minutes to make a
All right,
record.
go ahead and make a record.
Okay. The docket does not reflect that Cellini properly recused herself. I have gone mandamus and have successfully mandamus to order my family court judge back on the case. I don't think you are properly sitting in this matter. Cellini was decided.
He's challenging the judge on him being to rule on this case, despite the fact that the judge just ruled in his favor. He denied the TPO. What?
Assigned judge, both the rules and the statutes required once a judge is assigned to a case, they continue through unless for good cause that judge is disqualified or otherwise recused. I have a certified copy of the record showing Cellini initially taking this case. Furthermore, you did not put on the record that 32 years ago, you found me in contempt and threw me in jail for 10 days.
He's bringing back old shit with this judge.
And that a writ of mandamus was issued against you by Judge Earl White, which I have a certified copy of, and I would like to enter into the record. If you will not do so now in hearing, I will do so later at the clerk's office. This was by Judge Earl White. I have a copy for the
32 years ago, he held him in contempt. And now he's bringing it back up, even though the judge just ruled in his favor.
complainant, if you want to hand take that. A writ of mandamus granted in 1987 against you. So if there are any bias or prejudices on your part against me, I would like you...
Sir, I'm not even ordering the TPO. You're making a big money.
It's like, what are you talking about? I just ruled in your favor. What the fuck?
I denied the TPO.
I denied the TPO.
Your record is clear. I don't care if the mandamus against me or
I
not.
think you are not properly seated in this court, and I intend to challenge on mandamus. You're sitting in on this matter, and Cellini wrong.
But the matter is over. The matter is over. You won.
Wrongfully recusing herself.
Why
I've
are
had
you,
success
why
in this
are
matter
you,
before,
why are you,
and I think I will again.
sir, why are you challenging it? Because there's no TP being ordered.
But he has made false representation. He's
There's
perjured
no- himself
on the record.
All right.
And I have a right to bring that issue. If I cannot do it in this proceedings,
Oh my God.
I intend to file a TPO against him for harassment. Willful, malicious harassment. In
Please, everybody, like and subscribe. Please hit the like button if you're enjoying this. And sign up for my Discord. Thank you guys very much. Oh my God.
addition to the civil abuse of process
You can
suit
do-
against
you can
this
do-
gentleman.
sir,
I
you
use
can
that
do-
term loosely.
You can do whatever you want. You do whatever you want. It's a free world. Right now, this was an issue of TPO. There was no direct contact. I said if there be any contact, you promised me there wouldn't be any. There wasn't any. Therefore, no TPOs being issued. But I must remind you, you do have one in the criminal matter. That's not beside me. So
Right.
the case is closed.
But there's one last thing item there. The record is unclear. It said in the record that the TPO was supposed to be mutual, and you did not say that in open court.
No, it was never supposed to be mutual. Blandino, you never filed an order for a TPO. Federico did. So it was never supposed to be TPO. You are now being dishonest in the court.
In other words, it says we are both to stay away from each other for 30 days.
There
Was that record incorrect? I got a certified copy of that.
Well, you better stay away from each other.
No. What I'm saying is you specifically denied, when I asked for custody in that chair right there about a month ago,
Yeah.
I said, would you make it joint? And you said, no, I don't need to make it joint. However, the record does reflect that it was joint. Are you willing, does reflect that it was, would you make it joint? And you said, no, I don't.
From each other.
No. What I'm saying is you specifically denied, when I asked for custody in that chair right there about a month ago,
Yeah.
I said, would you make it joint? And you said, no, I don't.
You said, so he knows what the judge said at the time, but now he's claiming that the record, which would have the transcript of the proceeding, says the opposite, even though you're recalling what was said at the prior hearing. That he said, no, it's not mutual. But now you're saying the record reflects otherwise, which would invariably would be a transcript of the proceedings. What the fuck are you on about?
Don't need to make it joint. However, the record does
Yeah, this is pure gaslighting right now.
reflect that it was joint. Yeah, are you willing? Is it your intention to amend or clarify that record? And that, in fact, this 30-day time period that we just went through was a joint and mutual stay away from each other order.
If you want a TPO against him, you have a right to file it.
Thank you.
All right?
Okay. And I appreciate your patience. Thank you.
Have a good day, Judge.
Yeah.
Oh, yeah, sure. Good. That's for him to go first. All right.
Okay. Another
Ken Blandino.
All right, now we get to listen to another one where I think most of us have watched. So let's listen in. This is directly involving Blandino's criminal case.
State versus Kim Dennis Blandino.
Can we trail this?
No, we're not trailing it.
Kim Blandino appearing pro se for Kim.
I know exactly who you are. Be quiet. Here's the deal. This is on for one reason, and that's for confirmation of counsel. That's the only thing we're going to address. Is somebody going to confirm as his counsel? Oh, okay.
This guy isn't even here. That's why I asked to trail in part.
It will be trailed until he gets here.
And who was this?
I need to make a record, though, if I could, Judge.
I can't hear, I'm sorry.
Steve Alter is who's been contacted. Just have a seat.
Can I make a record?
Have a seat. No.
Okay.
Sit down.
I object.
I object to you.
I object to you. Shut the fuck up.
Then you have a problem.
Sit down.
No, you.
14, Your Honor. Comfort Welch.
State Nevada versus Kim Dennis Blandino.
Kim Blandino again, he appearing pro se for Kim Blandino.
Right. Mr. Alder, will you accept appointment as standby counsel?
I have an objection.
Shut up.
I have a right to object. I believe, Your Honor.
You have the right to get held in contempt of court. And that's what's going to happen if you don't shut up. I'm not putting up with any of your crap here today. Your reputation has preceded you. Will you accept appointment on him as standby counsel?
Your Honor, I can. However, Mr. Blandino's, after he spoke outside, wanted a little bit of time to speak to me in detail about his case and his desires, and then also to look into my background a little bit before he would agree to
You want to
accept it.
interview you?
Yes, sir.
I object to that laughing, Judge.
Good morning, Your Honor. Mike
I object to that laughing, sir.
Dickerson and Melanie Marlin on behalf of the state. In addition to this, we have one other matter that we want to address today.
What would that be?
We do have a motion that we'd like to file on serving the defendant in open court with the motion. It's a motion to remand defendant for competency proceedings.
We just asked them to
court.
speak today.
And we're going to ask you to speak that to when Judge Levitt is present here.
I think, unless I'm mistaken, I think the defendant has already categorized himself as a vexatious litigant. I mean, that came out of his mouth.
Kinda.
I object.
You should all you want. So how do you want to handle this?
I don't mind if we want to pass it out a week. Let me have an appointment with him in my office so he can talk to me in more detail.
Okay, that's fine. That's reasonable. Go up to his office, talk to him, interview him.
Can I make a record?
No.
I've got a motion.
What did I just say? What did I just say? No.
I can't say anything.
No. It's not on. It's on
No.
confirmation to council. That's the
We just
one.
filed a
And
motion in open court, and I can't respond to this?
you're going to respond to this.
I can't because the vexatious
You're gonna respond to D's nuts in a minute if you don't shut up.
litigant order that you referred to bars me from filing anything in the court without the chief judge's permission.
Yeah.
And for you not to
File
accept
it.
my
You
order-
file it.
No, you have no
File a
authority.
response.
You're
Hey,
impersonating
shut
the
up.
judge.
Shut up. You're getting real close to getting remanded. Go ahead and review this, because I'm sure that Judge Levitt is going to consider the state's motion, then Judge Levitt will consider your motion, okay?
I have not.
You gotta file it.
I have no permission. I have been barred under contempt, threat of contempt, if I file anything in this court without the chief judge's permission or the chief judge's designee. I can be found in contempt and thrown in jail for filing anything without review.
And you discuss your proposed motion with Judge Bell and see if she...
Bell has we have an unadjudicated motion to disqualify there, and so she is disqualified
Okay,
there.
okay. Bye-bye. Okay.
Bye-bye.
Could I?
Yeah. we're gonna set
That's
this-
gonna be September 17th at 8:30 a.m.
Okay. There you go.
And that's for the motion and confirmation to council.
Now, will Judge Levitt be there on that day?
Yes.
I'm sorry?
Judge Levitt be there on that day?
Yes.
September
Way
17th.
nicer than I am.
Okay. Thank you. I think you're very impatient, though, sir.
I think you're very impatient, sir. The judge is just chuckling on the way out.
All right. What can we do?
They're just like this fucking guy.
Your Honor, if we could call page 24, please.
You got it.
I think I had two more videos, but I think I might have to stop here because they involve another TPO request.
This film is
No, we're not touching that. Yeah, I'm gonna have to. It's from a different judge, and it's from a different person making the request for a TPO. So I think I'm gonna stop here. And we are going to have part 3. Part 3 will go through that TPO as well as all the remaining videos that have led up to what we saw at the beginning of this month. And but on tomorrow, either tomorrow or Friday, it's going to be the finale of Telling Lies. I promise. We're gonna finish up that game tomorrow or Friday, and then we're gonna have part 3 maybe this weekend. I'm gonna ask for Mike to join me on part 3. So yeah, we're gonna stop it here. I need to go eat something because I'm hungry. I haven't eaten yet since I got back from work, and I will thank you guys. I'm gonna go with before I leave the super chats. We have Clifford Reynolds, member for 13 months. Thank you very much, Clifford. Hey there, Artie. Glad to be here. Merry Christmas to you. Merry Christmas to you too, Clifford. Kiwi, Texas, 7 months. Artie, do we need to start a fund to get you a mini fridge? I already have a mini fridge. I just need to make room to put it in this PC room. I haven't done that yet, but eventually it'll happen. I still need to clean up some stuff. Some old dude, member for 6 months. Thank you very much. Only 107 likes for 400 watchers. I know. If you can, just hit that like button on your way out. I'd really appreciate it. It really helps the channel out. And if you haven't joined yet, definitely take care. Join my Discord as well. And lastly, auditor investigations for $5. Judge, I'm denying his TPO, but I'm issuing one that keeps you away from me. Yeah, exactly. Unfortunately, Kim doesn't take no or yes, apparently, for an answer. All right, guys. Have a good night. Take care. Adios.